Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Shipping Law Review, United Kingdom, England and Wales. So this is the third part of the video. Two contracts of carriage. The HQV's bureaus incorporate into English law by Carriage of Goods by Sea Act 1971 are the salient convention rules applicable in this jurisdiction. The rules will apply compulsorily to bills of lading when the port of shipment is in England. And Wales, or when the bills are issued there. Further legislation on the functions of bills of lading and contract of carriage has been enacted by the Carriage of Goods by Sea Act 1992. There is no specific legislation governing multimodal contract of carriage, although it is generally accepted that the HQV's rules will apply to the seagoing leg of such contracts for carriage. As yet, the United Kingdom is not a signatory to the UN Convention on the Carriage of Goods by Sea, or the UN Convention on Contract for the International Carriage of Goods, wholly or partly by sea. The Carriage of Goods by Sea Act 1971 qualifies that the contract falling under the Act, including bills of lading, governed by English law. There is no absolute implied terms of seaworthiness. The effect of this is to make the carrier generally dirty regarding seaworthiness, one of exercising due diligence. Following Article 3 of the HQV's bureaus, a carrier must exercise due diligence in the following cases: when making the ship seaworthy, when properly manning, equipping and supplying the ship, and when making holds, refrigerating and cool chamber, and all other parts of the ship in which goods are carried fit and safe. The duty is on the carrier personally, and it is not delegible to servant, against or contractor. Deck and live animal cargoes are excluded from the provisions on the HQV's bureaus. Pursuant to Article 3 of the HQV's bureaus, the carrier must properly and carefully load, handle, stow, carry, keep, care for, and discharge on the goods under the contract for carriage. Honor may rely on the differences at Article 4, Sections 2 of the goods in the care and are loss or damage. These differences include the act or neglect on the master in the navigation or management of the vessel, act of war and arrest or restraint of princes, as well as latent defect not discoverable by due diligence. Article 4, Section 6 states that inflammable, explosive or dangerous goods may be discharged or destroyed at any time before the discharge without compensation if the carrier has not contested, unless with full knowledge of their characteristics to carry them, unless notice of loss or damage is given in writing to the carrier or his or her agent before or at the time of receiver removing the goods into his or her custody, or within 3 days of doing so. If the loss or damage is not immediately apparent, the carrier will be deemed to have complied with its obligation as per Article 3, Section 6. In any event, the time limit under which a claim can be brought under the HQV's bureaus is 1 year from the cargo's date of delivery or the date on which it such have been delivered. Liens. The right to exercise a lien under English law may arise out of a variety of contexts, either pursuant to a contract or another legal relationship. Liens may be classed as maritime, statutory, equitable, or possessory, and each of these classes had a defined means of enforcement. A common characteristic of all liens is their functions of covering a proprietary interest in an asset as security for a claim and in enforcement against third parties. Liens generally do not have to be registered under English law. Maritime liens under English law are confined to 5 specific categories: bottomry and respondencia, damage done by a ship, salvage, seafarers' wages and salvage, seafarers' wages and master's wages and disbursement. These categories also overlap with the definitions under sections 20 of the Senior Court Act 1981, and some maritime liens may be pleaded as statutory liens in the alternative. Purely statutory liens are defined under sections 20 of the Senior Court Act 1981 and include claims for loss or damage to goods carrier in a ship, personal injury sustained in consequence of a defect in or wrongful act done by ships, claims relating to any agreement in relation to the carriage of goods in a ship, and claim arising out of General Average Act. Maritime and statutory liens fall under the umbrella terms admiralty liens, coming under the exclusive jurisdictions of the Admiralty Court and may be brought as general claims. English common law recognizes possessory liens, which confer the right to enforce a claim by means of retaining property already held by the claimant. Typical possessory liens include a ship owner lien on cargo for outstanding freight or general average contribution. If an owner or disponent owner under a time charter party has not been paid hire by the charterer, the owner may be entitled to exercise a lien requiring the charterer down the charter chain to pay direct to the owner the sub-hire or sub-freight that would ordinarily have been payable to their owners. The EWCA confirmed in the bulk Chile case that owners are able to exercise a lien over freight from the shipper under the bill of lading, as well as a lien over the sub-freights due under a charter party in a charter party chain. Sellers may exercise possessory liens over self-held property. Possessory liens can also be created by contract or stated. An equitable lien is a right to proceed against an asset pursuant to a claim arising from a contract or pursuant to the course of conduct. Equitable liens will bind third parties only if they have acquired a legal interest in their lien assets with notice of the lien. Cargo claims. The bill of lading evidences a contract for carriage obliging the carrier to deliver cargo against that document. Aside from charter parties, bills of lading are the fundamental element of cargo claims under English law. A common basis for English law cargo claims in the breach by the carrier of their duty under Article 3 or 3, Article 3, Sections 1 or 3, Sections 3 of the Hague Office Bureaus, namely a failure to exercise due diligence to make the vessel seaworthy or a failure to care for the cargo properly. Pursuant to the Carriage of Goods by Sea Act 1992, which is applicable to bills of lading, seaway bill and ship delivery orders, title to invested the lawful holder of the Bill of Lading. So the time is up and the article will be continued to read on the next video. So bye bye and don't forget to like, comment and subscribe. Bye.